Good morning, Malaysia. This is Matthias Chang from Future Fast Forward once again. Before I proceed further, may I request all of you to get your handphone ready to photograph the documents which I will show to you. Please do me a favor, because these documents can be WhatsApp to everyone in Malaysia as soon as you turn on the video. Because it's very important that Malaysians throughout the country know what they can do with regard to the 1MDB affair. The issue is no longer how much money has been stolen. We all know that. Alright? We know there's money laundering, there's corruption, there's cheating. So there's no need beating a dead horse. There's nothing the government can do to remove the tattoo that's been on your mind, my mind, that the issue, the kleptocracy investigation, the largest in history, by DOJ, by Singapore, by Swiss authorities, is beyond dispute. Now is a time when you and I, and more importantly, every MP of the opposition parties, every political leader, NGO activist who's worth their salt, who's saying going to champion for you and me as Rakyat, then you got to know as a Rakyat how to demand action from them. Without this knowledge, you have difficulty in demanding action, because we must not allow any MPs, ADON, leaders of opposition parties or NGOs to say that we don't know what to do. In my last two addresses, I give you details of the Financial Services Act 213 and what has been concluded and agreed by the Attorney General at Bank Negara. Crime has been established beyond all doubt by 1MDB, by the Prime Minister, by Jolo, by everyone. Alright? But what is important now is what action can be taken. Okay. So are you ready now with the handphone? For starters, I'll remind you again the press statement of Bank Negara, 28 April 2016. Please take it now. The first photograph. Okay? Now, in the second page of the press statement, it says here clearly, the payment of the compound marks the conclusion of the investigation by Bank Negara Malaysia on the contraventions to the rules and regulations of Central Bank. Bank Negara Malaysia, 28 April 2016. The keyword is marks the conclusion of the investigation. You follow me? What it means is this. The Bank Negara really said that they've completed the investigation. They've demanded certain actions by 1MDB to pay the fine, to repatriate the monies. Fine has been paid. Those are actions subsequent to the completion of the investigation. And I said to you before, that is the barest minimum. A bit of wayang kulit. But that action by Bank Negara, with the consent of the AG, of paying the penalty under the Financial Services Act, shows that they have confessed to the crime, paid the fine, they can't deny. However, you, the Rakyat, has been misled to believing that that's all Bank Negara can do, or for that matter, you, the Rakyat, the MPs, the ADONs, and all the opposition leaders, and those conscious, law-abiding, alright, religious MPs of the Barisan Nasional. If they are true to their religion, to their duty, they also can act. Let me say this to you. Okay. First, remind you again. Bank Negara's action and failures. First question is, why no action against Jolo? I've stated in my previous address, Section 214, Subsection 2, no person shall undertake or engage in any transaction set up in Schedule 14 except with the approval of the bank. This section applies to JOLO. Alright? The answer is provided in the act itself. And the answer is very simple. It's a yes. The answer is found in section 214, subsection 4. Unless otherwise expressly provided in this section, and Schedule 14, subsection 2, which I just read to you, shall apply. Shall apply means mandatory to A, all persons, classes, categories or descriptions of persons, including their nominees or any person acting on their behalf, notwithstanding they are not in Malaysia. Jolo was in Malaysia, was running around, screwing starlets, prostitutes, gambling casino, but acting all the time as nominee or on the behalf of MO1 Najib. There were times he came to Malaysia to attend board meetings and he declared he was acting in the cabinet as an advisor. So he's caught by section 244A. And then B says, all acts that are committed in or outside Malaysia, including any act which involves, is in association with, or is preparatory to the transaction set out in section 14. He was responsible for the JV with Petro Saudi and those JVs with ABA, and as well as arranging for the loan from Goldman Sachs. So he falls within 214, 4A and B. Alright? And the provision says, shall apply. The word shall apply is mandatory. Okay? My explanation, take it down. Jolo has publicly declared that was acting as an advisor to the Prime Minister and one MDB. And there was, from his BlackBerry telephone transcripts he had with MO1 Prime Minister Najib, it was clear he took instructions from and was acting for and on behalf of Najib as well as one MDB. This took place within and outside Malaysia. Okay? He also conducted banking transactions with regards to monies from one MDB to third parties and to himself and to the bank account of the Prime Minister. Subsection 2 says, shall apply. It means mandatory. Now, let's see. Besides imposing a fine, what can Bank Negara do? And I'm appalled. And I've been waiting and waiting because I can't do everything. I was hoping all these months, MPs and ADONs, MPs in Parliament, PAC and ADONs, and leaders of political parties, especially opposition, will take the initiative to push Bank Negara and the government and expose the non-action in Parliament. Instead, they're talking about debts, what have you. We have overcome all the issues, okay? What we want now is action for recovery. Here it is. Power of bank to take action. Administrative actions, no need to go to court. Section 234. A person has committed a breach of this act if the person fails to comply with or give effect to any provision of this act, any regulations made under this act, any order made or any direction issued under this act, and particularly 2146. Because I said section 214 and for this schedule applies to one MDB. To directions under 2146 applies to one MDB. Okay? Okay? And 4, any standards, conditions, restriction, specification, requirement, or code under this act. Conditions for the approval. Restrictions for the approval. Or the disbursement of the loan. Requirements. All these, any controversial. So there are 4. Section 2342 refers to matters which the bank must take into account in taking action. We're not concerned with that, right? Okay? Now, section 2343. If Bank Negara is of the opinion very low standard is required, is of the opinion that a person has committed a breach and is appropriate to take action against that person, the bank may subject to section 262 take any one or more of the following actions. It is of the opinion: A. Make an order in writing requiring the person in breach to comply with or give effect to. Have you photographed all these things, please? Or 2. To do or not to do any act in order to ensure compliance with such provisions, regulations, order, direction, standards, condition, restriction, specification, requirement or code referred to in subsection 1 before. B. Not relevant. C. Reprimand in writing the person in breach or require the person in breach to issue a public statement in relation to the breach if it is the opinion of the Bank Negara that such breach is relevant for the information of the general public. Can you see that? Bank Negara can demand the Prime Minister, Minister of Finance, the CEO to make public statements. Okay? Under the Act. No more hanky-panky, no more spin, no more propaganda, no more lies by Arukanda that there was cash in the bank, in BSI Bank, what have you. Bank Negara can give specific direction to come to make public statement for the purpose of informing the general public. That's what done. Make an order, D, in writing requiring the person in breach to take such steps as the bank may direct to mitigate the effect of such breach. Okay? It doesn't apply. So, we have not heard of any action by Bank Negara requiring one MDB and all those members of the cabal, the syndicate, to mitigate the loss. Now, these are very specific requirements and action which Bank Negara can impose, but has not done so. Now, section 2345, I summarize for you. States no action will be taken if at the time of the breach a person demonstrates that the breach was committed without his consent or connivance and that he exercises diligence to prevent the breach as he ought to have exercised, having regard to the nature of his function in that capacity and to the circumstances. This means he is deemed guilty of contravention of any provision of the Act or regulations or whatever, unless he proved he took pains and action to prevent the breach, did not connive and exercise due diligence. Not one statement at all from any board of directors, Arukanda, Mr. Finance, Prime Minister. Only 2 persons has the dignity, the courage of the conviction, and honesty. The first chairman of one MDB, okay, Tan Sri Bakay of Samdabi, and I think another chairman, second sec chairman, another Tan Sri, they resigned because they knew what was wrong. But the rest, the subsequent chairman of the one MDB and all the board directors, right, has not shown that they did not connived or exercise due diligence to prevent the crime. So they're all guilty. All guilty. Okay? Because they have not passed this test. Okay? And section 234 must be read in conjunction with section 253, which I referred to you earlier. Bank Negara can compound offences up to 15 million, which I referred to in my first 2 address. So I will not repeat that. Now, what's important is what civil action Bank Negara can take for which your MPs, your ADONs, NGOs can pressure Bank Negara to do. Section 239, where it appears to the bank that there is a reasonable likelihood, not beyond reasonable doubt, where there is a reasonable likelihood that any person will contravene, not just that, will contravene or has contravened, or will breach, or has breached, or is likely to fail to comply, or has failed to comply with any provision of this Act, provisions of any regulations made pursuant to this Act, order made or direction issued by the bank under this Act, including an order made under Section 94, not relevant, or a direction under Section 116 or 156, not relevant, subsection 2146, relevant, as I said earlier, applies to Schedule 14 or Section 216. D, not relevant. E, not relevant. Bank Negara may institute civil proceedings in the court seeking any order specified under subsection 2401 against that person, be it Prime Minister, Minister of Finance, members of the Board of Directors, Joe Low, all the scumbags. Importantly, whether or not that person has been charged with the offence, even not charged with the offence in respect of the contravention or breach, or whether or not a contravention or breach has been proven in a prosecution. Can you imagine? That means civil action will be taken regardless whether anyone has been charged for criminal offence or whether the prosecution has proven a contravention. So why no civil action taken? Because there's no need to wait for the completion of the investigation by the IGP, by MACC or PAC, or for AG to file a prosecution. It says here very clearly, may institute civil proceedings whether or not that person has been charged, whether or not a contravention or breach has been proven in a court by a prosecution. And yet, to today, no civil action taken on the misleading statement, the propaganda, the spin, and recently in Parliament, the Second Finance Minister says, I can't take any action because investigation is not completed. We're going to go half the story. IGP said the same thing, PAC worse, no criminality. But this act says Bank Negara can take civil action whether a person has been charged or whether it's proven under prosecution. Okay? And I have been charged. Can you imagine? For undermining the banking and financial services of Malaysia in prison. When I've done nothing wrong. Can you see the double standard? This heinous charge against me. The duplicity, the heinousness. Never mind. Let's go on. Section 240, which was referred to earlier by Section 239. The court may, High Court, on any application by the Bank Negara under Section 239, which I just quoted to you, make one or more of the following orders. An order requiring the person to pay an amount which shall not exceed 3 times A1, the gross amount of pecuniary gain made or loss avoided by such person as a result of the contravention, breach or non-compliance. 3 times the pecuniary gain made. They took the money, they gambled, they bought assets, they diverted to investment. 3 times the court can make an order against those person. Okay? Remember, 239 says no need to prove that they've been charged of prosecution. It's enough Bank Negara with the evidence to go to court to ask for this order, first order, to pay an amount, no, it's in 3 times the pecuniary gain, the financial gain obtained by these bastards, scumbags. 2, the amount of money which is the subject matter of the contravention. If 1 million was obtained, a loan, without the lawful approval or the approval has been revoked, that money taken by Joe Low into his personal account went for a round and round the world. That money must be repaid by Joe Low and all his cabal, his companies, okay? As the case may be. B. Any order requiring a person pay a civil penalty in such amount as the court considers appropriate. So above the two, the court can also impose penalty which it considers appropriate, having regard to the severity or gravity of the contravention, breach or non-compliance. But in any event not exceeding 25 million ringgit, it's not 25 ringgit, 25 million ringgit maximum penalty on all these scumbags who money laundered our loan. How come this was not done? And C, an order restraining the person from engaging in any specific conduct or requiring the cessation of the contravention, breach or non-compliance. D, an order directing a person to do a certain act. An order directing a person or any other person like Joe Low who appears to have been involved in the contravention, breach or non-compliance, to take such steps as the court may direct to mitigate the effect of such contravention, breach or non-compliance, if it's not relevant. And where a person has refused or failed to comply with any action taken by the bank under subsection 2343, an order directing the person to comply with such action as taken by the bank. Lies, and misleading the Raya. And I also blame the MPs who are lawyers by profession in Parliament. Why have they not made demand for this action? There is a remedy. First, administrative action by Bank Negara. Second, civil action in court. And you will recall, when I make reference to BMF, the final report of BMF by the Inquiry Committee recommended criminal action and civil action. But in our case, one NDB, no recommendation by Bank Negara, even though they are empowered to take civil action. Okay. And then H, any other order deemed appropriate by the court, including any ancillary order deemed desirable in consequences of making an order under any provision in the subsection. And who can make this order against? The court may make an order under subsection 1 against a person who is a director, members of board directors, controller, officer or partner, or was purporting to act in such capacity. Or B, who is concerned in the management of the affairs. That means the Prime Minister. Although not a director, he's an advisor, but an article of association, he was involved in the management of the affairs. Of a body corporate, that means one MDB, or unincorporated, in the event where contravention, breach or non-compliance has been committed by the body corporate or unincorporated, unless the person proves, like before, that the contravention, breach or non-compliance was committed without his consent or connivance, or he exercised due diligence to ensure no such offence be committed. But they have done nothing of that kind. So this order applies, okay? And then, subsection 6, the court may revoke or vary an order made by it under this section or suspend the operation of such an order. 7, the powers conferred on the court under this section are in addition to any other powers of the court inherent jurisdiction and do not derogate from its other powers provided under any written law. So the court can act pursuant to the Financial Services Act and any other written law. The hands are not bound by the provisions of the Financial Services Act. Applications under this section may be commenced at any time within 6 years from the date on which Bank Negara discovered the contravention, breach or non-compliance. So we have more than enough time to pursue the scoundrels. We have 6 years from the time Bank Negara discovered the contravention. When the Bank Negara revoke the approvals. April 2016. So we have the right to demand action as per Section 240 of the Banking Services Act. Interim orders. The court can even give interim orders like injunction. Section 242. If an application is made to a court for an order under subsection 241, 2401 or 2411, the court may, if it deems appropriate, before considering the application, make an interim order of the kind applied for, and such order shall be expressed to have effect pending the determination of the application. My explanation. The kind of interim orders can be a waiver injunction or an ante pillar order. To preserve the stolen assets and ill-gotten gains, an order for waiver injunction can be applied for. To discover any documents, etc., that will determine the location of other assets, ante pillar order may be applied for. And there is a prison, as I said earlier in my address, the BMF case. The Supreme Court case of Esprata against Bank Bumi, Malaysia Berhad. What happened if the court makes the order and someone contravenes the order? Section 243. Any person who contravenes an order of the court under subsection 2401 or 2413 or section 242 commits an offence and shall a conviction be liable to imprisonment for a term not exceeding 8 years or to a fine not exceeding 25 million ringgit or both. Subsection 1 does not affect the powers of the court in relation to the punishment of contempt of court. Now, most important, other actions by aggrieved person, you and me, that means you and me, Section 245 says, an application made pursuant to subsection 2401 or 2411 shall not prejudice, that means shall not affect our rights, any other action that may be taken by Bank Negara, aggrieved person or licensed person, as the case may be, under this act or under any other written law. Licensed person means the banks, financial institutions licensed under the act, Bank Negara. Aggrieved person means you and me. Why? Because under the Banking Financial Services Act, under the general provision, section 1, there's no definition of aggrieved person. Likewise, under section 213, which provides a definition, a glossary of definition, for the purpose of 214, it has not defined aggrieved person. But the wording of 245 is such that, right, the aggrieved person can be you and me, MPs, ADONs, because we are taxpayers. Alright? The one MDB is a company under Ministry of Finance, it's a government entity, and the government is supposed, alright, to act on our behalf to ensure no loss. Any loss, we end up paying. Alright? So we can definitely come under a aggrieved person. But I'm asking all of you, the Rakyat, to go after, alright, your MPs, your ADONs. They can file action, because if an MP can be a member of a PAC to investigate on such matters, more so they have a right under this act, this provision 245, as a aggrieved person, as our representative, our wakil, to take action. So the question is, why have they not? Why have they not? Now, to conclude, remember I told you about BMF? The inquiry report, final volume says the committee recommends Bank Bumi take action. As well as the government, I think. But the government will be subject to advice by IAD, Attorney General. This was a corruption on grand scale within a private entity. Bank Bumi is a listed company, not within the control of the government. Okay? This is different. One MDB. If BBMB can take action, what more? Alright? Our government. Because no one is above the law. Not the PM, not the finance minister. No one is above the law. And if Bank Negara, if Badan National, UMNO, MC, MIC, Gerakan, says that they represent the people, they fight for justice, for truth, then they better do take action. Why have they not? So now, for your convenience, I have not produced, right, the actual law report of Espata Sri Berhad against Bank Bumiputera Malaysia Berhad. Okay? Espata are the appellants appealing against the order of court granting various orders to Bank Bumi, and Bank Bumi is the respondent. Supreme Court, 1988, 1 MLJ, page 97. Okay? Take the handphone and photograph. You got it? I count 15 seconds. And 1, and 2, and 3, and 4, and 5, and 6, and 7, and 8, and 9, and 10, 11, 12, 13, 14, 15. And page 2 is the various reasons for the Supreme Court to make the relevant orders. Please photograph it now. Send to everyone. Show to your numbskull MPs and adults who pretend not to know, who are too lazy to go to court or to get a copy of the law reports. Here, you show to them so there's no excuse or deny that they don't know. Okay? It starts from right here. Held a judgment of the Supreme Court. 8 paragraphs. You got it? 8 paragraphs. And I had it in yellow for you so you know which paragraph are important. Okay? Now, come back to the first page. Come back to the first page. Let me read to you. Okay? The respondent had brought Bank Bumi an action against Lorraine Osman, who was a director of the first respondent bank and the chairman of the second respondent. First respondent is Bank Bumi, second respondent is BMF, for a total sum of 27,625,853.06, which they claim to be secret profits made by Lorraine without their knowledge and approval. The respondent made an ex parte application for a bereaver injunction to restrain Lorraine from transferring his assets out of jurisdiction, and also for an order of discovery for Lorraine to disclose the value, nature and whereabouts of all his assets. The orders were made on January 10, 1985, but could not be served on Lorraine, and the learned trial judge of the application of the respondent's bank extended the bereaver injunction to Lorraine assets in 32 other banks, in addition to the 6 banks cited in the earlier order, and also to his shares in 104 other companies apart from Espata Sri Berhad, and the 4 companies mentioned in the original order, for the purpose of restraining Lorraine from distributing his assets up to the amount claimed in the writ. The court also granted an intermittent order against Espata Sri Berhad, which was subsequently varied and extended to other companies. See, Lorraine Osman tried to hide the assets and ill-gotten gains in numerous bank accounts and companies, 104. Now, how come we have not got any statement whether Joe Low, 1MDB, KC Tang, Jasmine Lu, PM, has diverted other money in other bank accounts? And in other companies. Okay. And here is what the court said. I have to read to you, please. Held the additional powers of the High Court conferred by Section 225(2) of the Courts of Judicial Act, which under paragraph 6 of the schedule includes the power to provide for interim preservation of property, the subject matter of any cause or matter, by injunction or in any manner whatsoever, are wide enough to confer jurisdiction on the High Court to provide injunction in the manner of the Mariva injunction. 2. Paragraph 6 of the Schedule of the Courts of Judicial Act, read with Order 29 of the Rules of High Court, and Section 50 of the Specific Relief Act is wide enough to confer the necessary jurisdiction to issue Mariva injunction prayed for, although Parliament may find it necessary in future to impose whatever limitation it may deem fit in exercise of that discretionary power. In this particular case, the learned judge was satisfied on the evidence before him that the respondent's bank had shown that they had a good arguable case, that the defendants had assets within jurisdiction, and there was a risk of the assets being removed before judgment could be satisfied. In the circumstances, the learned judge not only had a jurisdiction to grant the Mariva injunction prayed for, but he had also granted the injunctive remedy on correct principles. 4. On the facts of the case, there were good and valid reasons for granting an injunction and allowing it to continue. The appellate companies need not to be made parties to the proceedings before the ex parte injunction could be granted. The essence of the Mariva injunction is speed, and as such, the learned judge was correct in issuing the ex parte order against the companies after lifting the veil, the corporate veil, although the appellants were not then parties in the ex parte application. 5. In the ex parte inter partes Mariva proceedings, all relevant affidavits properly filed must be considered by the court, and therefore affidavits filed after the ex parte application, in this case, were admissible in the inter partes proceedings subsequent to the granting of the ex parte Mariva injunction. 6. The court could generally lift the veil of incorporation in order to do justice, particularly when an element of fraud is involved. There was admittedly an element of fraud in the receipt of the secret profits alleged in this case, and this was sufficient for the court to lift the corporate veil for the purpose of defining or of determining whether the assets of the company were really owned by them or Lauren Osman. In this case, the corporate veil having been properly lifted and Lauren having been exposed as the alter ego of Espartra, it became necessary to identify all assets within jurisdiction owned by Lauren Osman. The entered below order granted by the learned judge in aid of the Mariva injunction was necessary as it was in aid to justice as far as the response were concerned. This was an appropriate case to grant the Mariva injunction together with the entered below order after the corporate veil has been lifted. You see what I'm trying to say to you? There is administrative action available to Bank Negara. They did the minimum. They can do more. They have not done so. There is reference to civil action. All the orders which a court can make under the Act as well as under any other written law. That's why this judgment is very relevant. There was reference to the Court of Judicial Act that empowers the court. Specific Relief Act that empowers the court to give injunctive relief. This example shows that beside the Financial Services Act, which actually says the court has other jurisdiction over and above what is provided for in the Financial Services Act. As a result of all the combined powers and authority, the court went after Lauren Osman. Even though Lauren Osman was not a director of Espartra. It's a little hard, huh? PM, Prime Minister, Najib, Finance Minister, is not a director of 1MDB. Now Lauren Osman vis-a-vis Espartra. The court said, we have to lift the veil of incorporation. We have to go behind the corporate mask and see who is in control of the company. After lifting the veil of incorporation of Espartra, discovered all the ill-gotten gains, the assets. That's why injunction was given, Mariva injunction, so that Lauren Osman could not transfer his assets out of Malaysia elsewhere and hide. That's what I said in the first 2 video addresses, am I right? Lifting the veil of incorporation. Jones and Littman, Guildford Company against Horn, as well as other cases in the House of Lords. So how come no one, especially MPs who are lawyers, who has law firm, refuse to lift a finger and pretend they don't know? Not possible. Not possible. I waited. I brought this up earlier because I felt I've done enough. As a rakyat, I've done enough. I was hoping that these people, the MPs, the adults, who are lawyers by profession, who are accountants, they ought to know the law. Even accountants, they know about lifting the veil of incorporation. Because accountants are also sometimes them act as liquidators. They need to know the law. And we know that everything to do with 1MDB is governed by the Financial Services Act 213 and Schedule 14. And yet, after 2 years, time is wasted debating in Parliament as to whether the government has taken the debts off 1MDB. Whether or not the government has taken over debts, they left the issue hanging about criminality. AG has consented and confirmed crimes have been committed. Compound offered, fine offered, they pay. Therefore, habis cerita. Now we're talking about enforcement. And the Act says, Bank Negara can do all these things even if a person is not charged or the charge has to be proven by prosecution. In the opinion, a reasonable likelihood of a contravention to be committed or has committed. Civil action is not proof beyond all reasonable doubt. Civil action burden is on the balance of probability. In fact, in the case of such case like that, Bank Negara has even lower burden of proof. In the opinion. Why? Because the integrity of our banks, the integrity of Bank Negara is a priority. And yet, I've been charged under SOSMA for so-called undermining the integrity of the banking and financial services of Malaysia, for reporting the crimes. Can you imagine? Can you see now the difference? The hypocrisy, the double standard. My client made a police report. I was advising my client to ensure transparency, to ensure compliance. Here the Bank Negara, in his opinion, or thinks that it's the likelihood of contravention or breach or non-compliance, can take this action to protect the integrity, to protect sabotage, the real sabotage, not the Trump charge against me. Nothing has been done. And it's provided, besides the Bank of Negara, an aggrieved person can also take action. So, fellow citizens, please, after this address, WhatsApp your MPs, your ADUN. Just WhatsApp. Why have you not taken action? As a great person, as MP, or our wakil, why have you not demanded further action in court by Bank Negara or yourself as Member of Parliament or ADUN? If you don't do that, Rakyat, don't complain. Don't curse. Don't swear. Our country is broken. You have now the solution. You have now the means to move forward. It doesn't require you to make any sacrifices. I'm not asking you to go to jail. I'm asking you have a right to go to your wakil in your constituency. That's all you have to do. Go to your wakil, Member of Parliament, or your ADUN. That's all. You can't be allowed to be charged. Your right to demand information, clarification, and action. Do that. Or else, you deserve the government that will be elected in the next election. Okay? I will not mince my words. I'm sick and fed up to have you do this. Have I not done enough? And some of you even have the audacity to say, my view is just too long. I challenge any one of you can summarize in 5 minutes the documents of my research. I took the trouble, even over weekends, I work my guts out so that you, the Rakyat, have a benefit of this knowledge. So use it to your advantage and stop moaning and groaning and take positive action. And once again, need not fear. Surrender to the will of God Almighty. He will protect you and me, defend you and me, and guide you and me under all circumstances in the face of all enemies, adversity, challenges. God works in mysterious ways, isn't it? As I said in the first two address. Now this third address, again I show to you. Once you commit a crime, you go against the will of Allah, He will punish you. His wrath will descend on all these scumbags, these liars, these crooks, these criminals. Have faith. Please help me. I can't do this alone. Go throughout the whole length and breadth of the country. First time in the history of Malaysia, a Prime Minister has confessed to a crime, pleaded guilty to a crime, and paid a fine for the crime. Okay? 214 Financial Services Act. With that, I thank you for your attention, and I hope you'll take my advice and proceed accordingly. May Allah bless all of you. You have a good day. Be strong and firm. Victory is ours. Thank you.